aye.
Aye.
To the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 34, to Clause 1, in the name of Sarah Olney, with which will be convenient to consider Amendments 36, 37, 38, 202, 39 to 44, name clause 1 and 45, new clause 1 and 45 to 47. I call Sarah Olney.
Thank you, Madam Speaker. Madam Chairman, I beg your pardon. Pleasure to serve under your chairmanship, and thank the member for Spen Valley for her opening remarks also. I'm grateful to be called so early in the session to be able to talk, because this, I believe, is one of the really important issues before us as a committee, considering this particular piece of legislation, and it surrounds whether or not somebody has the capacity to make the decision to end their own life.
Sorry, it's taken me a while to find this in the bill, but just on the issue of the advance directive, which I think is a really interesting discussion, and I'm glad we're able to have it. Is he reassured that in clause 18 of the bill, subsection 4, it's very clear that actually on the day that assistance would be provided to a patient, the doctor has to once again assess capacity to make the decision to end their own life, and again has to check that it's a clear, settled and informed wish to end their own life. And indeed has to check everything again on the actual day, including capacity. So I believe that would negate the issue around advanced directive.
Dr. Neil Shastri-Hurst.
Well, I'm grateful to the honourable member. She makes a reasonable point, and I agree with her on many issues. On this, I have some reservations, and the reason for doing so is because what Clause 18.4 says is the coordinating doctor must be satisfied at the time of the approved substances provided that the person to whom it is provided has capacity, has cleared, settled, informed wish to end their life. But of course, through the wording of section 26.1 of the Mental Capacity Act, that decision can be made at an earlier time and deemed to have currency once capacity has been lost, for the enactment of that act at a future date. And therefore, I think there could be some minor tightening up of the wording there, or reassurances from government that may be able to alleviate that point. But I think it's an important point to air and raise. I'm going to give way to the honourable member.
I'm not in that position. They are making day-to-day lives. They are living in supported accommodation. They are making the kind of decisions we've discussed in this debate. Buying a coffee, going to the bank, etc. And I know from my 20 years as a counsellor, and in the last 11 years since our children were born, I've become so involved with a number of our local disability charities. Those decisions that people make when their child is at that transition age, trying to understand the complexity of having to make that power of attorney or those decision-making issues for their child. I spend a lot of time actually with parents who don't put those measures in place because they don't understand the complexity at that age, and therefore could have a young adult in this position where that young adult is relying on doctors who do not know them. And at the moment, because the amendment hasn't been tabled and I haven't seen the amendment, so I still talk about the judge at this stage, a judge who has to take that level of decision making about that capacity.
Would the Honourable Member give way?
Kim Leadbeater.
I don't particularly have a question to ask the member, but I just want to pay testimony to him for the way that he has engaged so positively with the process of going through this bill, and to pay tribute to him for the very personal experience that he shared with the Bill Committee. And I want to reassure him that I will do everything I can to work with him, as I have done so far through this process, because his fears are real, and I hear those fears. And I think we've got a job to do through the bill to solve problems that exist for people who are dying, but what we don't want to do is create other problems, and I would be very happy to continue to work with him to make sure we address as much of that as we can through this bill committee.
Daniel Francis.
Thank the member in charge for her comments. That's the conversation we had when she invited me to join this committee, and we'll continue to have those conversations, I'm sure, as those amendments come forward. But my concern is about some aspects.
I want to speak in support of the Honourable Lady's amendment to replace the Use of the Mental Capacity Act with a new ability test. This does go to the heart of the bill. It's absolutely crucial, and clause 3, which her new clause would replace, is in a sense the essence of the bill. It's the shortest clause, but it's perhaps the most important one because it determines the means by which somebody will be assessed to be capable of making this decision. It's a very, very important protection. And at its simplest, and it is a very confusing and complicated area, I'm going to confuse myself, no doubt, of course, in my speech. But I do have this very simple observation to make, and the Honourable Lady made it very well. We're dealing with the issue of impaired judgment. And currently, under the Mental Capacity Act, it will be possible, by the terms of this bill, for somebody whose judgment is impaired by virtue of a mental disability or mental illness to successfully apply for an assisted death. I don't think that's what the public want. I don't think it's what the House of Commons voted for. I think it's a misunderstanding of the principle of the bill that did win support at second reading. The simple fact is that your judgment can be impaired under the Mental Capacity Act, but you can still have capacity. And we've heard repeatedly points made about how the Mental Capacity Act applies in the normal conduct of life for disabled people, for people with mental disabilities. And for instance, you can be anorexic, you can be suicidal, you can be depressed, and of course you can still consent to all sorts of decisions that are made that affect your life, including medical treatments. You can have surgery on a broken leg while depressed, and you can consent to that, no difficulty whatsoever. Of course that's appropriate, and that's the right basis on which we currently judge capacity. And the amendment that the Honourable Lady is introducing will build on the terms of the Mental Capacity Act. It adds to the principles of autonomy and of people being able to understand, use and weigh the relevant information. But as I said in an earlier intervention, the key point is that using this new test of ability will ensure that the person is fully able to do those things.